against negative press, if you like. It's monitoring that ensures its integrity. Let me just deal with some of the... I said you can judge for yourselves as to whether or not you feel these things are right. I just want to go into some of the provisions of the Act and to talk in particular, to start with, about pre-charge. Now, you may or may not know that some of these detainees have now been in custody for 10 months without charge. The five that I represent, were all arrested on separate matters, trivial matters, nothing to do with violence against the person or anything like that. I say trivial, some of them might have been to do with dishonesty and what have you, but certainly not related to violence and nothing related to crimes that are now 40 years old. Arbitrarily arrested on other matters, then rearrested once in custody for things to do with 1971. We don't know what yet, because there hasn't been any prior disclosure whatsoever. The detainees haven't been served with a single piece of paper detailing what it is that they're likely to have to contest later on. There is, therefore, from the word go, no opportunity for a defendant or a prospective defendant, because they haven't been charged yet, to even think about preparing their defence, because they don't know what it is that they're facing. Now, that is how it is, I'm afraid. It goes further. Interrogations have been taking place recently, and why not? They've been in custody for long enough. It's about time they were actually given an opportunity to put their side of the story, except where I come from, and no doubt where most of us come from. If you're in police custody, if you are going to be questioned about an offence that you are suspected to have committed, you're usually given the luxury of A, some advanced disclosure as to what it is you're going to be asked about, and given that these people are likely to be facing crimes such as genocide, it might be helpful for them to know what exactly they're supposed to have done. And B, for them to be attended by a lawyer. During the interrogations, lawyers are not allowed in the room. They're not even allowed to see what's going on in the room. They are unable to prevent the investigator who's been conducting the interview from holding a spontaneous press conference halfway through the day and addressing the waiting press, announcing how the defendant or the detainee has confessed to genocide and to all manner of other crimes. But there's no formal record of the interview. And when the suspect is visited finally by his lawyer the next day, he says, I never said any of these things. I did what you told me to do. I said I've got no comment to make. Well, let's just for one moment accept, which we are assured didn't happened, and that is that a suspect confesses everything in interview. What right does the investigator have to go to the waiting press outside and spill the beans as to what has been going on during what must, in ordinary circumstances, be a confidential interview? How does that impact upon the fairness of a trial? How does that impact upon a defendant who may later on say, well, actually, I never said those things, I want to go for trial? Oh, yes, you did, you admitted everything. How does that impact upon the fairness of the process? How does that impact upon the perception of the general public? In other countries, that would never be allowed to happen. The trial would be stopped by the judge immediately. And what's more, is it not a contempt of court? But nevertheless, that's what happens. I've been told I've only got about 4 or 5 minutes left, so I'm going to have to push on. The trial itself, is it independent? Is it independent when, from bottom up, all actors are appointed by the government? The investigators, the prosecutors and the judges, all appointed by the government. Is it right that the tribunal or the Act should deny defendants any chance of challenging or making interlocutory challenges to other courts? It's ruled out. Is it right that the defence should be called to prove beyond reasonable doubt the existence of an alibi or any other specific fact in the course of their defence? Is it right that if the defence should call a single witness, the prosecution are entitled to address the bench last when it comes to speeches? Is it right that the judges have an unfettered right to question witnesses, the defence with no right of re-examination after that questioning takes place? Is it right that rules of evidence, traditional rules of evidence, should be specifically ruled out from the trial, such that, as stated by the Act, the judges may take judicial notice of what is contained in magazines, press reports, newspaper cuttings and television reports from the time? It becomes trial by rumour rather than trial on the evidence. And is it right that the prosecution can get away with serving their case papers on the court just 3 weeks before the trial, where there is no specific requirement in the Act for the defence to receive any disclosure, any statements, any evidence at all before the trial starts? But bearing in mind this is a capital case, that's what we have. I want to just wrap up now, and I want to talk about the context. The Awami League won a landslide election victory in the end of 2008. One of the central planks of their manifesto was that they were going to have this trial. After they won the election, they swiftly acted. The original plan was that members of armed forces should be tried, and 195 Pakistani soldiers were arrested, tried, but pardoned in the early 70s. The whole thing was put to bed. And there was generally a pardon issued by, I think it was Presidential Order number 16 of 1973. Everything was put aside. But what happened in 2009 was that the government woke it back up again and issued an amendment to the Act that said we can now try individuals. The individuals have one thing in common. They're all luminary members of the opposition. And now you start to see this may be a politically motivated trial. There's a constitutional article, and I'm going to finish on the Constitution, that says, and it's Article 31, to enjoy the protection of the law and to be treated in accordance with the law, and only in accordance with the law, is the inalienable right of every citizen. The constitutional amendment contained within Article 47, I haven't got time to go into the detail, but it explicitly rules that out in terms of those charged under the tribunal. So not only the rules of evidence go, but constitutional rights under 31, 35 and 44 go as well. So my final word is this: the constitutional point is absolutely paramount. And where I beg to differ respectfully with Ambassador Rapp is here. It's all very well to encourage the government to tinker with the rules and try to bring things up to common day standards within the rule framework. But unfortunately, the rules will always be subservient to Article 47 of the Constitution, which explicitly rules out any safeguard, any protection for those facing prosecution within this tribunal. The Constitution has to be amended. Without that, we have to trust a prosecutional authority that has already shown itself to be fundamentally flawed and tainted by political motive, leaving a dangerous and pernicious constitution dominating a tribunal that, at the moment, can only lead to disaster. I think I've gone over time. I'm stopping there. Thanks very much for listening.
Thank you very much. And,